in the judgment that she puts forward on what I should see or what I shouldn't see, but she needs to have a pretty good idea of the things I know about, the things I need to know more about, and the things that are going to be of particular interest or importance to me.
That's fair. So it's not just the NSIA.
No, but it's primarily the NSIA, as you said.
Fair enough. But so it's a close two-way working relationship then.
Very, very.
And we've also heard that the part of the NSIA's role is to sort of play a convening role within the national security community. So it's a significant role. And there have been suggestions made, for instance, in the NCERA report, that the role should be formalized in a legal instrument. We've also heard talk in these commission's proceedings from the clerk, I believe, who suggested the idea of a mandate letter, perhaps. What are your thoughts on that?
Over the course of the years that I've been Prime Minister, we've had a number of different changes to the National Security Advisor role. One of the changes I made reasonably early on was actually adding National Security and Intelligence Advisor, because it wasn't just about security. Intelligence was becoming more and more important in our approach. But from one NSIA to the next, there were significant changes in the threat environment around us, in the composition of the senior ranks of the public service and the different roles. When Ian Shugart was my clerk, he came at that role with such a deep and expert understanding of international issues, of intelligence issues, that he played a role not just as a clerk, but as a significant national intelligence and security advisor to me, just as through his capabilities and personality. And therefore, the actual NSIA I had at that point had a slightly different role than in other times where the clerk wasn't as much of a national security focused individual and had other qualities, and the National Security Advisor was really the person who was centered around that for me. So those natural variations, and for example, the fact that right now my National Security and Intelligence Advisor is also Deputy Clerk of the Privy Council, which I think is very useful in this case, isn't necessarily automatically something every future Prime Minister would want. Therefore, the idea of bounding in very prescriptive legislation, the role of a National Security and Intelligence Advisor, I think would be probably less flexible than the role actually requires, because the most important part of the role is that the individual be empowered and connected to the Prime Minister in the right way, but also able to command the town or the intelligence agency's respect and be able to convene. So some of the things we've done to strengthen and almost codify that role are around the creation of the National Security Council, which is more of a strategic convening of ministers and top officials to look forward around larger issues, as opposed to an IRG, incident response group, which is to respond to a specific incident. This is a more strategic look, and the role of the National Security and Intelligence Advisor is to be the secretary to that council, the same way the clerk of the Privy Council is also secretary to cabinet. It's a role that gives them an official lever in convening and controlling the work done at that particular table, whether it be a cabinet for the clerk or the NSC for the NSIA. So that has already strengthened and codified to a certain extent the role of the NSIA. But we have found that publishing mandate letters that delineate clearly my expectations of what, in most cases, ministers, which is what they're directed at, are expected to do and what authorities they have and how they're expected to function, has been incredibly useful, a tool that is very bespoke for the moment you're in and the kind of organization that your government has particularly set up. Publishing the mandate letters means that the public knows clearly what is expected of these individuals. Journalists and academics can dig into, whether a particular official or minister is fulfilling their role as expected and how they're doing on that. But the most important use of the mandate letters we've actually found is internal to government themselves. We find that public servants in various departments regularly consult the mandate letters that we have published so that they know exactly what the minister is responsible for, what they're actually trying to do. And a mandate letter for the National Security and Intelligence Advisor would seem to me to be an excellent use of both empowering and clarifying the expectations of a given government at a given moment in a public way, but also an accountable way.
So that would be a way to maybe give some structure without compromising on flexibility?
I wouldn't say that, because it's not the mandate letter that gives the structure. The way we set up the office, the way we task and empower, various parts of government is inherent. The mandate letter would would reveal that structure and give direction on the outcomes that we want to have. And I think that's where it could be useful.
Okay. I'm going to come back to the National Security Council because it's something I want to discuss in more depth. But before that, and before leaving the topic of information flow more generally, there's a couple of intelligence products that have come up repeatedly in the Commission's proceedings that I want to ask you about. One is called the targeting paper. And so this one is, just to introduce it briefly, a document that was drafted by CSIS in 2021 about the PRC's essentially targeting of Canadian political actors for influence operations. And it wasn't published in 2021. It was published in 2023 and circulated to a small number of public servants. There was a second, more sanitized version with, for instance, names removed, produced of it. And the intention was that would be circulated more widely. And we've heard from the CSIS director, Mr. Vigneault, former director, that in his view, that should have been provided to you. So last time we broached this topic, Prime Minister was in camera, and at that time you'd never seen the targeting paper at all, and I understand that you now have. Okay.
Yes.
Having seen it now, do you have any views on whether it's something that should have come to your attention in 2023?
Well, one of the reflections I have on how this sort of piece of analysis has caused so much reflection around this commission and various chatter is the phrase targeting paper by China is fairly alarming. What the targeting paper actually talks about is that China has broadly classified into three different groups parliamentarians in their diplomatic activities, some as being positive towards China and perhaps there to engage in constructive ways, others who are neutral or convincible to be more positive towards China, to show up at various events, and others who have demonstrated themselves to be more antagonistic to the Communist Party of China's government by speaking out strongly on the Uyghur issue or on human rights in Hong Kong or on various other of the issues that China doesn't like people to discuss publicly and criticize them on. The fact that Chinese diplomats are categorizing MPs in their outreach abilities into those three categories is not itself particularly revelatory to me or new information to me. It is fairly obvious, and it is part of what diplomats do in every country around the world. I mean, when we are busy fighting to defend or renegotiate NAFTA with the United States under the Trump administration a few years ago, we had very clear lists of, okay, this Republican governor could be very helpful to us. This one is going to be a challenge, so let's stay away from them or try and come at them or try to neutralize their influence on others. That's just part of diplomacy right there. I will say that having read the targeting paper in detail now, there were some interesting factoids or tidbits in there that I said, oh, okay, that's interesting. None of them significantly altered at all my perception of China's behavior, China's focus, China's engagement, influence, and in some cases interference in Canada to any significant degree. And I count on my national security and intelligence advisor to look at various products to make a determination whether or not they are ready to go to the Prime Minister. I think in both of these cases, the papers were the other special report that you're going to be talking about in a moment were not in a final form according to the NSIA, and therefore there wasn't a decision made to pass it along to me. I have to trust the NSIA's judgment, as I said before, in knowing what is going to be useful for me, what is going to be an appropriate use of the 10 or 15 minutes worth of time that would take to go over a document like this, whether it adds to my knowledge or whether they're in those 10 or 15 minutes that she has to submit other information to me, there is more germane or more relevant information that she thinks would be a better use of my time. The determination was made in the case of this targeting paper, or the targeting paper didn't get to me because of decisions made by the NSIA or not made by the NSIA in terms of not choosing to pass it along. And I have faith, having looked at the paper, that it was indeed the right decision by the National Security and Intelligence Advisor, that it wasn't a document that significantly added in a relevant way to my understanding of the situation.
Okay. Just for clarity of the record, the evidence we actually heard from the NSIA at the time, Jody Thomas, was that she never received the final version. So she never even made that decision that it wouldn't go up to you. But so you brought out a couple of interesting themes in that answer, and one of which, yes, you've been paying attention, because the next document I was going to ask you about is the PCO special report. So why don't I go there, and then I'll ask you some more general questions about the two of them. So the special report then was the product produced by IAS, the PCO Intelligence Assessment Secretariat, late 21, early 2022. And this was, for everyone's benefit, drafted in collaboration with CSIS, and essentially an overview of PRC foreign interference activities in Canada. This, as you've said, is one that wasn't finalized and ultimately never reached you, and that you have now read. So in that time period where this was under discussion would be winter, spring 2022. And now, having read it again, and you may have given part of this answer already, but is that something you would have wanted to have at that time? And are there any problems ensuing from the fact that you did not receive it then?
Again, there were elements and facts and examples in there that I had not seen before. But the overview and the pulling together of information, while useful, I'm sure, for people who were coming at this without the kind of regular briefings that I got, could have been very useful. I don't feel that there was anything in there that I didn't already understand and know about how China was engaging across different fields in Canada. It wasn't particularly new. It was a very useful and good piece of work that combined and compiled everything. And for someone new to the job would have been extraordinarily important. Even not just new to the job of Prime Minister, new to a role in the office, or trying as an introductory level of okay, now you need to understand this. But it was a compendium of many themes that I have been grappling with over the past number of years in regards to China. And I, again, feel that the NSIA was justified in not feeling that it was imperative that they put it rapidly on my desk, particularly because, as you say, it wasn't yet in its final form.
Okay. We're actually going to move to I'll come back to some of the questions I was going to ask you in themes around that, but I'm going to move to a different topic for now, which is unclassified briefings to parliamentarians. And for this, I'll ask the court registrar to pull up COM 363, please. And if we can scroll down to paragraph 126. Prime Minister, for your benefit, this is a discussion about a succession of memos suggesting that essentially unclassified briefings be provided broadly to parliamentarians. And what we see here is that NSICOP made this recommendation in 2018 and 2019, and there are 3 memos that were intended to go to you in some way, shape, or form. So one in December 2019 that was sent to PMO but never followed up on, and we heard from your staff that sort of fell through the COVID cracks at the beginning of the pandemic. One in December 2020, which was discussed within PMO but ultimately not actioned, and then the report mentions one in 2022, which was never finalized or even sent to PMO. So just to confirm, first of all, that none of these memos ended up reaching you. Is that correct?
Correct.
Okay. And we know that this initiative of broadly briefing parliamentarians eventually did happen in June 2024. So if none of these reached you, first question I'd like to ask is, should this have happened earlier? And are you troubled that it didn't?
My position has always been that providing more briefings to parliamentarians is a good thing. I am fully in favor of it. We all receive security briefings when we first get elected on not leaving documents hanging around, being careful about when you're speaking about delicate matters in a restaurant or on an airplane or anywhere people can overhear. We learn the basics of phone hygiene and how to keep your information secure. And I'm a huge believer in empowering parliamentarians to be able to be safe and thoughtful in how they do things. The briefings to parliamentarians that you receive when you get elected and security briefings ongoing are not directed by the government of the day. They're directed by the House of Commons itself, the Sergeant at Arms, if it's a matter of security, the Speaker's office. Briefings to all parliamentarians is not in general something that the government of the day is directly involved in. But these various documents are certainly something. CSIS has the authorities to go to either the Speaker or the Sergeant at Arms and request for those briefings. These briefings didn't get to me, but these decision points didn't get to me, but I made it very clear throughout conversations that I would have approved of or encouraged briefings of parliamentarians. There is a process that I see regularly invoked. About every week or so, I sit down with the clerk of the Privy Council and we go over changes to the senior ranks of the public service. We talk about particular issues that are coming forward, and part of our regular meetings is the clerk highlighting, okay, there's this note that we sent to your office that has been there for a week or two or for too long, and we need a return on this because this is important and we need this to be acted on. And I'll say, okay, we'll follow up, and we dig it up from the pile of notes that we get and make sure that we prioritize that. In this case, nobody, neither CSIS through their minister to me or directly to the clerk or to the NSIA, flagged that this was something that was of importance to them that was stalled. And therefore, as you pointed out, they were not acted on in my office.
Why was your approval being sought, do you think? Like, was your approval necessary for this initiative?
As I said, my approval was not necessary for this initiative. It certainly wasn't wrong for them to check if they wanted to. I wasn't insulted that they did, or I wouldn't have been insulted that they did. But it wasn't part of the necessary steps. Often we get things for information. Oh, by the way, the minister is going to approve this. You should know about it, but it's within his or her authority to do. This is for information, not decision for you. Those are notes that we receive regularly that obviously when they're relevant or germane, they get dealt with either through the office or directly to me. But in this case, the authority was not necessarily mine to give.
Okay, and would it have fallen to a minister, for the Minister of Public Safety, for instance?
I mean, it could have, or the CSIS could have checked in with its minister. The Minister of Public Safety is directly the minister that oversees and is responsible for CSIS. I know that the director of CSIS has direct access to the Minister of Public Safety in a very regular way. If there have been concerns around this, the CSIS director could have gone to the minister either for a signals check or for help in moving it through the approvals process in the Prime Minister's office, or to even check that maybe I should just go straight to the Sergeant at Arms in Parliament to actually take on this briefing. And as far as I know, CSIS did not bring up this with even its own minister.
Okay.
I have one question, Mr. the Prime Minister.
Oui.
Do you have any idea why no reply was ever given to all of those that requested the authorization?
Well, I think as was stated in the first case, it was in process when COVID happened, and we all moved to different priorities and virtually. In other cases, in the third case, it actually didn't get to my office. In the second case, no, I don't know why.
Okay, because if an authorization is asked from your office and no authorization is needed, at least in your view, usually do you, not you personally, but your office give the information to the person requesting the authorization, or not at all?
It depends on the amount of the amount of notes, the various priorities of them as they go through. I really can't speak to the challenges around that particular one, other than saying that I was always very clear that briefings to parliamentarians is a good thing.
Thank you.
Okay, the next possibly related, possibly not topic I want to talk about is ministerial accountability in the foreign interference space. So if we can bring up CAN 030999. Prime Minister, these are notes. This is not something you would have seen. This is notes or minutes from DMFI, which is Deputy Ministers on Foreign Interference Committee meeting in April 2023. And if we can just scroll down so we can see the third and fourth bullet there. The NSIA at the time here was Jody Thomas. And This is a discussion that was had at that meeting on essentially where ministerial accountabilities lie in the foreign interference space. So if we see that, I think it's the third bullet on the page, the NSI mentioned that the day before public safety, the clerk and deputy clerk had a discussion about foreign interference, during which the clerk mentioned that the ISR, so this is in the period where the independent special rapporteur was doing his work, seems as though they're comfortable with the panel in sight, but what's becoming more obvious is gaps on how FI is handled between elections, specifically what's the role of deputies, staff, and where's the ministerial accountability more broadly. The second bullet then says, as a result, the NSIA has asked PCO to begin work on mapping this. So how is intelligence circulated? How are ministers informed? How do they exercise their ministerial accountability? The governance, she says, seems to work well at the deputy level and even between PM and PMO, but that gap at the ministerial level may be a concern. So we discussed this a bit with the NSI at the time, Jody Thomas, and what she said about this, and the reference for the record is at WIT 151, paragraph 81. I won't bring it up, but I'll just tell you about it. The conversation around ministerial accountability was that in the NSI COP and NCERA reports, as well as the media leak discussions, everything needs to go to the PM. But in fact, in a Westminster style of government, ministers have accountabilities. So that was the nature of the discussion that was being had at this meeting. From your perspective, how does this play out? Was there an issue with ministerial accountability in the foreign interference space?
I think what you're outlining is sort of the second part of the conversation. The first part of the conversation is clear to me, and I can't really speak to what Jody was sort of digging into there. But it's very clear from the first bullet the gaps on how FI is handled in between elections. I think the important thing to remember is when we created the site task force, the panel of 5, it is because during an election, during the writ period, the government is in caretaker mode. So there actually are significant limits on how and whether ministers and prime minister will continue to be ministers or prime ministers even during an election. But they are limited in what they can actually go out and say, particularly if they're about to say that an opposition party is compromised or benefiting from interference by a third country in an election context. That would be destabilizing and of concern to do. That's why we set up the panel of 5 top public servants to be able to address during a writ period and publicly speak to what a particular piece of foreign interference is trying to have as its impact on an election. That makes total sense as a structure during elections, but during a by-election, where we've actually made sure that the site looks in on that, you don't have a caretaker convention. During a by-election, the government continues to be the government. The Minister of Public Safety or Foreign Affairs or the Prime Minister continue to be fully empowered to do all their works. And therefore, it would be during a by-election if there was a significant concern that a particular country was engaging in massive misinformation, disinformation, it would normally be the minister who would do that, who would talk about that and be accountable for that communications and those actions. But because of the partisan nature of the event that is a by-election, there's a discussion on, well, whether that ministerial accountability should be there around that, or whether officials should take on the communications, even though it's not in a caretaker convention. There are arguments to be made on both sides, and that's the kind of issues that we're grappling with around interference in our democratic institutions and the fact that one party was selected by Canadians to wield the full authority of the state, which in general times is very clear and, hopefully without partisan spin or questioning. but in situations of electoral contexts become more delicate. So where we could say, oh, the caretaker convention means that government is not fully active and leaning in as ministers and prime minister during an election period. What you actually do during a by-election is the question that they're digging into around ministerial accountability.
Okay. Well, let me take you back to the National Security Council at this point. And can you tell us a little bit about how and why that council was created? We understand I think it was September 2023 it was stood up.
Very rapidly after 2015, we created a mechanism to deal with various crises, whether it be a particularly dangerous storm or flood or weather event that was affecting a particular part of the region that required engagement from multiple ministries. You can imagine transport having to weigh in, environment and climate change coming to the table. Maybe there's a national security nexus, so the public safety minister needs to be there for overseeing policing. We created something called an incident response group. And this could involve either a natural disaster or a specific terrorist threat that we saw coming or needed to respond to after it actually hit. Various responsive, specific measures where we would gather the relevant ministers and the top officials, the deputy ministers, around the tables, and everyone would contribute in discussions, as opposed to often cabinet meetings or cabinet committees where the ministers usually speak for their departments and their officials. Maybe a deputy minister will weigh in at one point and complete what the minister says. But in general, the conversation is ministers are speaking for their departments around committee tables. The IRG, Incident Response Group, was useful in that it elevated the deputies to be full participants around the table. So you had both the political lens and the top officials lens dealing in a very open way that allowed us to coordinate across bodies on a specific incident that happened. And we, unfortunately, because of the times we're in, have been using incident response groups much more regularly than I think we ever hoped to over the past number of years. But we realized in having those conversations that sometimes those conversations would have a stretch at the last part that said, okay, how do we then strategically look forward to the next incident like this and already prepare for being able to better deal with it? And we said, well, that's not really responding to this incident. There is a need for a larger outlook, a more strategic outlook where we can sit down and gather everyone around the table to talk about a particular theme and position Canada strategically over the coming decade, perhaps, in our positioning. There have been a number of those meetings already, and they have proved incredibly useful, where ministers and deputy ministers and heads of agencies that in relevant positions are all gathered around the same table. It's managed by the Prime Minister, but the NSIA is secretary to that council. And it allows us to dig in on a very significant and specific theme. Might imagine themes, and I don't want to go into too many details, but might imagine themes being around how Canada positions itself around its Indo-Pacific strategy, which was sort of what our outlook and our engagement on the region, which would involve a whole bunch of different parts of government and obviously involve both security and trade and diplomacy and all these different things that would come together in a cohesive view that we could plan out with that national security lens on it. Or another one was how we're approaching our critical minerals. The opportunity Canada has to be a supplier of the critical mineral ingredients to both the green and the technological transformation the world's going through that is right now perhaps constrained in supply by a particular country. Canada stepping into that space and being able to be a reliable supplier of critical minerals that are essential to national security around the world is a theme that is worthy of a big strategic discussion. So that's how we created the National Security Council, and in its meetings so far, it has proved an extraordinarily effective tool.
Okay, so it's, just to summarize a little bit of what you said, it's a strategic body, essentially, specifically on national security issues, which now brings, as you say, both deputies and ministers to the table, sort of along the lines of taking the model of the IRG in that sense, but not ad hoc. It's something that's more long-term and strategic.
It's not regularly scheduled. We don't have one every couple of weeks. It is thematically. When there is an important discussion to be had, we will convene. I mean, they come together at regular intervals and we plan what the next ones will be. But we could have, one every few weeks, like we could go a month or two without having one, depending on the theme, the time of year, all those things. So it's not as rigidly scheduled as, say, cabinet meetings or even cabinet committee meetings, but it is a legitimate, powerful tool. But you're right, it's not entirely ad hoc, but it is not regularly scheduled.
Okay, so I appreciate that you don't know, or you can't speak to the discussion we were looking at in the DMFI minutes here, but in terms of getting the people around the table and having these conversations, and I understand it's not a cause and effect thing necessarily, but does that assist in ensuring that there is sort of those conversations happening between ministers in the national security space?
Yes.
Okay. And in the timing of its creation, September 2023, why was that the right time to do it in your view?
I believe there was a recommendation from, maybe it was NCIRA, maybe it was NSICOP, maybe it was a parliamentary committee or some other source that highlighted that this was a good thing to do, and it had already been something that we were thinking about. Coming out of the pandemic, which was a significant crisis for the government, we were very much looking at different ways of being able to better respond to and learn from the things we did well, the things that we could improve on in future pandemics or crises, to realize that this was a body that made sense for us to put together to handle things like this. I mean, to a certain extent, the COVID committee that we had throughout the course of the pandemic, I think played a bit of a role of somewhat IRG, but also strategic overlook. And we wanted to replicate the effectiveness of that committee in a more flexible way to be able to cover different themes around the real strategic threats to Canada.
You mentioned also that the IRGs were becoming more and more frequent as a result of things that are going on in the world, more crises, more IRGs. I'm wondering if you can speak to the shifts in the geopolitical landscape that have happened, especially in recent years. I think we can probably, it's not terribly controversial that Russia's invasion of Ukraine, for instance, was a watershed moment. How have those affected the national security threats that Canada faces? And has there been a sort of corresponding shift or evolution specifically in the foreign interference threats? Not just Russia, but these more broadly, the shifts in the geopolitical landscape.
I think there is no question that foreign interference and in general threats geopolitically have increased significantly around the world over the past number of years. Obviously, as you say, Russia's invasion of Ukraine, the pandemic itself in terms of a destabilizing crisis for the global economy and for countries around the world, the rise of the tools around social media, misinformation and disinformation that were present back in 2015, but not nearly as sophisticated or pervasive as they are now, have caused a lot of challenges. One of the other things is in 2015, as we watched the American impending election of Donald Trump and the rise of right-wing populism around the world, that seemed to be one of the big threats or big concerns that we had that was potentially destabilizing. Things like Brexit coming along, Donald Trump's election. There was a lift of right-wing populism. It was very much the moment we were living in 2015, 2016, 2017, and grappling with as a responsible, progressive, rule of law democracy that believes in facts and evidence as the basis for policy decisions, as we are as a government. But over the subsequent years, it is not just about sort of right-wing populism that is still there. There is a significant rise of authoritarianism and an aggressive decline of democracy and democratic values in many corners of the world that are aggressively attempting to destabilize mature democracies, where populism can sometimes sort of twist the rules and the emphasis and twist the facts a little bit for its own gain. The attacks on the cores of our democracy and our institutions that the authoritarian narratives and attempts at disinformation and propaganda and sowing chaos in our democracies are much more serious and severe over these past years than they have been. We need only to look at the headlines this week to see the extent of interference activities and the impact they have on Canadians. But we've seen that with a rise of a more authoritarian China and the arbitrary detention of two Michaels. We've seen that through the complete rejection of the UN Charter and the rules-based order by Ukraine's being invaded by an authoritarian Russia. The world is more uncertain and less safe than it ever has been. And the answer that Canada needs to give is to double down on the rule of law and on the international rules-based order that protects us all. We cannot allow might to become right once again in the world. I mean, we have the multilateral rules-based order as a protection against that, and the fact that Russia in particular has chosen to upend that, along with other countries, is something that Canada must countries around the world.
Well, as you say, the headlines this week also reflect that, and we'll come back to those as well. Before we break, I do want to talk about or begin the discussion on the development of the government's response to foreign interference in the face of all of this or earlier. And I'll start with talking about the HASA-MC, so the Memorandum Cabinet on Hostile Activities to State Actors. And I'll ask the court registrar to pull up here COM Sum 4, which is a summary of that MC. So this we know is a major cabinet initiative in the foreign interference space that has been discussed in the Commission's proceedings. If we can zoom out so that you can see the 4 bullet points, essentially. Next page, there we go. 1, 2, 3, 4. So we see a number of elements in the strategy here. One is the first broadly endorsement of the counter HASA strategy. The second is a strategic whole of government communications approach. The third is consultations on legislative tools, the CSIS Act, Criminal Code, and the Security of Information Act. And the fourth is new capabilities for the RCMP. So in all of this, we know that this parts of this at least eventually became the legislation that we know fondly as Bill C-70, which was introduced into Parliament in spring of 2023 and recently passed into law in, I believe, June 2024. So first question I want to ask is what happened in that 2-year interval? So the HACCP being ratified in June 2022 and Bill C-70 coming into law in June 2024. It took 2 years for that to develop. Can you explain why that happened, and did it happen quickly enough?
Sorry, it absolutely happened in the time it needed to happen. Anytime you are giving more powers to security agencies to counter, in this case, hostile actions by state actors, or anytime in general you're giving more powers to security agencies to do new things, to counter new threats, you have to be very, very careful about the balance you get on protecting citizens' rights, protecting diaspora communities that could be affected, by protecting marginalized groups that have historical and systemic reasons to be worried about authorities having more powers to enforce, to police, to investigate on them. You know, it is not a small thing to grant new powers to counter new threats to intelligence agencies. And that's why, you know, in the process of C-70, there were multiple visits to cabinet over subsequent years. There were multiple rounds of consultations with different diaspora communities, with stakeholder groups, with human rights defenders and you know, charter rights groups. We knew that getting a significant piece of legislation that would strengthen Canada's ability to protect itself from national security threats from other countries was something that was delicate and that needed to be done right. I mean, we had the example of Bill C-51 in the last years of the Harper government, where the balance wasn't gotten right. We committed in that election that we would repair the balance on that, and we did rapidly after getting elected, and strengthened the balance to make sure that we were, even as we were granting new powers to intelligence agencies that were relevant and needed, the protections of fundamental rights of Canadians, and particularly of vulnerable groups, were strengthened in our measures that we took in the first years in office. So we had direct experience that getting this balance right is really important. As people may remember from the 2015 election, the NDP leader, Thomas Mulcair, made it a huge point of contention for him that the violation of charter rights within Bill C-51 were fundamentally so egregious that it was terrible, not just that Stephen Harper put those forward, but that myself and the Liberal Party would actually say, no, we're going to accept those improvements, but we're going to fix them as soon as we get elected, which we ended up doing. We chose to not play politics with issues of national security, and we said it's not what we would do, and we will change it if and when we get elected. But that experience deeply informed our approach to building C-70. And I think that the result of the work that we did with C-70, the fact that it passed through the House with broad support and the Senate with broad support and is now in place and active without significant outcry by minority communities or concerned groups, shows that we did do the work to get it right. And getting this right and building consensus around these issues was a fundamental goal of this government. And quite frankly, when C70 passed, there was criticism that we'd moved too quickly on it. As you highlight, there's also criticism that maybe we took too long for it. Doesn't always work this way, but in this case, I can say that it probably means that we took about the right amount of time to get it right, certainly because it was passed and is generally seen as, by all parties, as an effective and important piece of legislation.
So, Madame la Commissaire, est-ce que vous vouliez ajouter?
Madam Commissioner, do you want to add something? No, I'm okay, just listening. If you have any more questions before the break, that's okay.
Prime Minister, the second question I want to ask on that is it enough? One of the Bill C70, obviously countering foreign interference, countering hostile activities of straight actors is an even broader term, but one of the criticisms we've heard is that the government has not done enough in this space and has not done enough to counter what is now a recognized threat. How would you respond to that?
Well, I think, first of all, I mean, I'd heard that criticism as well, or the frame that, well, since you had to, do C70, obviously there was a mistake in the powers that CSIS or intelligence agencies didn't have before. You're correcting a mistake or an error or a shortcoming that existed before you corrected it. And I think that's the wrong way of looking at it. I think we are in a situation where the threats are constantly evolving, whether it's newer technologies, the advent of AI, the shifting and pervasive impact of social media in how people collect their news and understand the world around them, and the vulnerability to foreign interference and misinformation and disinformation that comes through that vector that wasn't the case even 10 years ago. The shifting geopolitics, where you have more assertive authoritarianism, countries like Russia willing to invade a neighbor on the flimsiest of justifications, means that the world is changing in very real and dangerous ways that require us to step up. And at no point would I say that C70 is enough and we can now sit back and coast on this for the next few decades because there will be no need to adjust and add more. That would simply be irresponsible. There is always going to be more work to do on ensuring that our agencies have the necessary tools to keep Canadians safe, while at the same time protecting the freedoms and rights of everyone in this country. And that is the constant, rigorous, responsible work that a government needs to do, to constantly be questioning, well, what more can we do to keep Canadians safe given these new threats, given these new challenges? How is the best way to do it while upholding the democratic and fundamental values and freedoms that is important to Canada? That's a constant debate in which not just the government, but stakeholders, communities, and even opposition parties have, and all parliamentarians have, an essential role to play in. It shouldn't be about partisan disagreements, whether, or a basis for partisan attacks when it comes to the question of protecting Canada's citizens, its institutions, and its sovereignty. And the kinds of debates we were able to have around C70 and the kind of consensus that we had around getting it passed indicates that, to a certain extent at least, there is an understanding amongst parliamentarians that we shouldn't be politicizing or overly partisan in our approach on these issues of fundamental safety. We need to challenge, we need to make sure we're getting the balance right, and that different parties coming from different perspectives with substantive challenges to it is a really important piece of it. But my expectation is that there will pretty much always be, through the life of any parliament or over the coming decades, there will always be some sort of tweak or improvement or adjustment to our national security infrastructure that is being debated or looked at or legislated on or studied or reflected on an ongoing basis. Keeping Canadians safe is not a one-day job. It's a constant, regularly updated, foundational priority for every government every single day. And it'll come together in certain pieces of legislation, but there's always going to be more to do, and that is the work that government continues to do.
C'est peut-être un bon moment pour
This might be a good time for the break. Okay, so we'll take a 20-minute break and we'll be back at 11.
Order, please. Alors, s'il vous plaît. This sitting of the commission is now in recess until 11 a.m. Cette séance de la commission est maintenant suspendue jusqu'à 11 heures. The hearing will begin shortly. La séance débutera sous peu. Order, please. À l'ordre, s'il vous plaît. This sitting of the Foreign Interference Commission is now back in session. Cette séance de la Commission sur l'ingérence étrangère est de retour en session. The time is 11:02 a.m. Il est 11h02.
Thank you. Before we continue, Commissioner, just one quick clarification for the record. Apparently, I said that Bill C-70 was introduced in the spring of 2023. Obviously, it was not. It was spring of 2024. Counsel for the Attorney General was careful to remind me of that. Okay, moving on with our next topic now. Prime Minister, I'd like to ask you about responding to foreign interference in a federal environment. And to do that, I'm going to ask the court registrar to pull up CAN 44456. And again, zoom out so we can see, that's great, we can see the summary. So Prime Minister, you may recognize this. This is a memorandum that was sent to you about a letter received from the Yukon Premier, Raj Pillai, about responding to Canada's relationship with India and sharing intelligence with premiers. And so in this summary, we learned that Premier Pillai has expressed some concern at a lack of consultation with premiers regarding national security incidents and the inability of security agencies to share classified info with them. He also notes support for the normalization of relationships between Canada and India. I suppose that was then, this is now. But in any event, can you speak to the challenges really and how managing national security in an environment where this is essentially a federal responsibility but touches provincial jurisdictions as well is done?
Well, I mean, I think we've seen over the past number of years that attacks on our democratic institutions, attacks on our democracies do not limit themselves simply to federal electoral events or federal parties. Provincial parties, municipal elections even have had have proven to be targets of note for foreign interference as well. So part of what we wanted to do within Bill C-70 was explicitly make it possible for CSIS to grant appropriate security clearances to provincial premiers so that they can actually have a better lens on protecting their institutions and also their citizens, in addition to the work that the federal government does to protect their citizens.
Okay. And jurisdictionally, as you mentioned, foreign interference can touch not only subnational governments, but areas that fall within provincial jurisdiction. And how can that be ameliorated, or how can those relationships happen? And what role can the federal government play in that space?
Well, I think part of protecting Canada, protecting our institutions, and protecting Canadians and our economy means people who have authority and responsibility over various aspects of our country should be able to be fully informed of the threats and look at what the responses are. I mean, one of the classic examples is there's a number of times where we've seen cyber attacks, significant cyber attacks, which are not foreign interference, but significant cyber attacks on provincial institutions, whether it be power grid or hospitals. The federal government has significant and deep expertise in cyber defense and cyber capacity. And it has been only over time that we have been engaged by the provinces to strengthen their defenses, as opposed to having each province build up its own exclusive cyber jurisdiction. It makes more sense to lean on the federal expertise and the federal tools to protect hospitals or whatever, even though they are fully within provincial jurisdiction. So that sort of collaboration between orders of government has been happening for a while in the cyber realm, can and should happen much more in the interference realm. But in order to do that, it'll be important that the appropriate people, premiers in this case, get the security clearances. It shouldn't be the federal government directing, for example, what's going to happen in a municipal or provincial election. That would be not appropriate. And quite frankly, sort of against the Constitution and the structures that we have in place as a federal government, as a federal system. But empowering the premier to be able to access relevant classified information that impacts upon their structures or institutions or their members and their areas of responsibility is exactly the right kind of principle. And that's something that this government has enabled and will continue to. So we're happy to do that. To go back to even before C-70 was passed, there have been instances in which we have directly brought in provincial premiers on issues that are directly relevant to them, but systemizing it in a much more robust way is what C-70 accomplished.
Okay. We can take that down now. Thank you. And for the next part of the question, you can pull up WIT 160. So these questions, Prime Minister, are going to focus around some intelligence regarding MP Michael Chong. And this goes back to, well, let me ask you first, actually. When and how did you first learn of allegations concerning the PRC targeting MP Chong in any way?
I learned about them in the media after a criminal leaked that classified information.
So we've heard about intelligence products that were circulating in 2021 that spoke to this issue, and I take it from your answer that those never reached you.
No.
Okay. What was your understanding when you did learn of this in May 2023 then of what the nature of the threat to MP Chong was? Well,
obviously, like most Canadians, when I read the accounts in the paper of what the classified information actually was purported to have said, my instant reaction was to turn to my NSIA and officials and say, find out what exactly the threat is, and if it indeed is this, why am I only learning about this in the newspapers, in the media? Yeah, that was my first reaction.
Okay. And if we just zoom out a little bit on this so we can see the discussion that was had in camera about this. Paragraph 2, I believe. There we go. So sort of towards the end of that paragraph, you know, Prime Minister, that while this was extrapolated through the leaks into China's going after Michael Chong's family as a way to pressure him, that's not the assessment that the professional analysts made. Can you speak to that?
Oh, that is an example where criminal leaks of classified information can be damaging to reputations, to people's confidence in our institutions and in our intelligence agencies. The conclusion that was drawn, I think it's a little further down on this page by the director of CSIS, is that there actually were no direct physical threats to Michael Chong or to his family. But that's certainly not the impression you get from the leaks of classified information that were selective and certainly portrayed in a way that looked much more serious than they actually were. This is not to minimize the fact that it is a real issue that China has chosen to single out for particular attention parliamentarians from all different parties that have stood most clearly and strongly against Chinese actions in regards to Uyghurs and in regards to the rights of pro-democracy protesters in Hong Kong or what have you. But the stories that circulated around this, that they were going after Michael Chong's family, are simply not borne out by the actual intelligence or the analysis by intelligence officials.
Okay, let me stop you there and just ask the registrar to pull up Can Sum 17, please. So take the witness summary down and put up Can Sum 17. This is a topical summary that was produced by the government for the commission and contains publicly disclosable information on this topic, PRC interest in Michael Chong. So can we zoom out quite a bit so I can see most of this page, please? Thank you. So in the first couple of paragraphs there, what this document says, Prime Minister, is essentially, it talks about that, the Uyghur motion, and then the PRC having imposed economic sanctions on MP Chong in relation to this. And these sanctions are in keeping with the PRC sanctions regime, which allows not only sanctioning of individuals, but their family members as well. And then you'll see the second paragraph that that option to sanction family members wasn't invoked in the case of MP Chong. Mm-hmm. If we scroll down now, and I think around paragraph 10, so I think in somewhere in this document, there we go, paragraph 8, I think is what you were referring to perhaps, and in this document at least, the CSIS director emphasized that CSIS intelligence did not reflect direct physical threats to MP Chong or members of his family or intention to cause physical harm. And then the last paragraph talks about how building process of using information through open sources and gathering information on MPs is part of regular diplomatic activity, which I think goes back to something you mentioned earlier this morning. In that vein, I'd like to ask you, because when your officials testified yesterday, counsel for MP Chong put to them, well, that may well be, but we know that the PRC is a repressive regime, and we know that it has a history of taking action against dissidents, particularly in Hong Kong. So with that in mind, how can one say that it's convincing that there were no threats against MP Chong or his family? What's your reaction to that?
Our intelligence professionals, our intelligence services examine threats to Canadians every single day and have to make determinations around which are credible, which are of concern, which require action, which require notification. I will highlight that even before the criminal leaks, there had been threat reduction measure meetings with MP Chong by intelligence officials who shared with him, the concerns about China's interest and negative views of him. That is entirely in keeping with the analysis and the roles and the responsibilities of our intelligence agencies.
Okay. We can take that one down now. Thank you. Within about a week of this article appearing in the Globe and Mail, significant action was taken by the government in response to PRC foreign interference, the PNGing of a diplomat named Zhao Wei. So we went through this in, I would say, painstaking detail with your officials yesterday, so I'm not going to take you through the succession of meetings, but I will ask you, first of all, the authority to PNG a diplomat, that lies with the Minister of Foreign Affairs, not the Prime Minister, is that correct? Okay. Is it something that you have to approve at all?
No, it is not something I have to approve, but it is always a decision that I am, at the very least, apprised of, but more accurately engaged in terms of the discussions and the deliberations, because kicking out a diplomat is a big thing, not a small thing. And it is right and proper that the authority be at the foreign minister level, but it is something that, as Prime Minister, I am very much kept in the loop on. And, my perspective on that, positive or negative, is certainly taken into account by the foreign minister.
What was your understanding of why Zhao Wei was being PNG'd?
Three things. First of all, over the past number of years leading up to this, there have been increasing instances of foreign interference by China and increasing moments of Canadian officials informing China directly that their interference activities were unacceptable and needed to stop, needed to decrease, they needed to stop attempting to interfere in Canadians' lives and in our institutions. That perhaps had its most clear moment in the G20 meeting in Indonesia, where I directly informed Premier Xi that he needed to make sure that China ceased interfering into Canada, into Canadian democracy. It wasn't a conversation that went particularly well, but it was a conversation that needed to be had and that we had. However, despite that and many other messages to China, the interference continued and even in some cases increased. So that was part of the reason why we needed to make sure there was a clear consequence. Secondly, as we looked into it, as the allegations around Michael Chong were surfaced publicly, on digging into it with the Foreign Affairs Ministry here in Canada, it was clear that even though in the case of Michael Chong, Zhao Wei was not engaged in interference so much as influence, that is, regular diplomatic collection of information with the goal of sanctioning, for example. So in the case of Michael Chong, not direct interference in the analysis of our intelligence agencies, but in other cases had been involved in interference activities. We realized that was a reason to look at kicking him out of the country, that he was involved and known to be involved in foreign interference, even if it wasn't directly in the case of Michael Chong. And third, the fact that there needed to be consequences for China. He'd been involved in foreign interference activities. And third, it had been made public, meant that he was also not going to be able to operate as a regular diplomat in Canada anymore. His utility as a diplomat to both Canada and I guess to China had ended because he was so clearly outed in the media as being a bad actor. Those three things together meant that to give a consequence to China, to give consequences on foreign interference, and specifically the fact that he was not going to be much use as a diplomat anymore, we chose to kick him out of the country.
Okay. I'm going to move
And
now.
actually, I think we asked China to remove him from the country first. And when they didn't, we said, okay, well, then we're going to have to kick him out.
Okay, so one last chance, and then he was gone. I'll move now to another event that led to the PNGing of a diplomat, this time an Indian diplomat, which is the murder of Hardeep Singh Najjar. I'll ask the court registrar to pull up WIT 106, please. So there's a few things to talk about in this, and if we can scroll down to paragraphs 52 to 55, please. There we go. So the first question I'll ask you to take us through, Prime Minister, is what led to your announcement in the House of Commons in September 2023?
Over the course of the summer, I was apprised by my intelligence services that there was credible intelligence that agents of the government of India were involved in the killing of Hardeep Singh Najjar. This is something that we had actually asked the intelligence agencies to look into, because following the rather high-profile killing months before, the initial assessment was, oh, this was gang-related or criminal-related. There was not an obvious, immediate international nexus to this. And that's how we were briefed after the meeting, after the killing in the days after. However, hearing directly from a number of our South Asian members of parliament and seeing and talking with members of the South Asian community around who were quite insistent that it was something that was likely connected to government of India. We actually asked the intelligence agencies, and it turned out they were doing this anyway, to look in more closely to the circumstances around this particular murder. So in late July, early August, I was briefed on the fact that there was intelligence from Canada and possibly from Five Eyes allies that made it fairly clear, incredibly clear, that India was involved in this killing. Agents of the government of India were involved in the killing of a Canadian on Canadian soil. This was something that we obviously had to take extremely seriously. That violation of sovereignty, of the international rule of law, with extrajudicial killing in a foreign country, in a fellow democracy, was a massive mistake if India had indeed done it, and we had reasons to believe that they had. So our immediate approach was to engage with the government of India to say, and we had our various security officials reach out to India and say, look, there are real concerns that your security agencies were involved in the killing of Najjar. We need to work on this together because that can't stand. we need to make sure that there are changes and there's accountability for this process, but let's try and do it in a responsible way that doesn't come and blow up the relationship between Canada and India. And that was the attempts we made in the month of August. As we approached the end of August and September, the big thing that was happening was India was itself hosting the leader of the summit of the advanced economies of the world, the G20. So it was a big moment for India, welcoming the world, all the leaders of the world to Delhi for a very important summit. And we had the opportunity of making it a very uncomfortable summit for India if we went public with these allegations ahead of time. We chose not to. We chose to continue to work behind the scenes to try and get India to cooperate with us. Their asks of us was, well, how much do you know? Give us the evidence you have on this. And our response was, well, it's within your security agencies. You should be looking into how much they know. You should be engaging. It's, oh, no, tell us what you know. Show us the evidence. And at that point, it was primarily intelligence, not hard evidentiary proof. So we said, well, let's work together and look into your security services and maybe we can get that done. No, we're not doing that. It culminated with a conversation I had with Prime Minister Modi on after the end of the last session at the G20 in Delhi, where I sat down and shared that we knew that they were involved and expressed a real concern around it. He responded with the usual response from him, which is that we have people who are outspoken against the Indian government living in Canada that he would like to see arrested. And I tried to explain that freedom of speech and freedom of people who come to our country to be Canadians to criticize governments overseas is, or indeed to criticize the Canadian government, is a fundamental freedom of Canada. But as always, we would work with them on any evidence or any concerns they have around terrorism or incitement to hate or anything that is patently unacceptable in Canada. And we have taken action in the past. We continue to take action. Even as I emphasize, and I have emphasized regularly, my position and Canada's position is to defend the territorial integrity of India. One India is official Canadian policy. And the fact that there are a number of people in Canada who advocate otherwise does not make it Canadian policy, but also does not make it, is not something that is illegal in Canada. Having done all that, we returned to Canada, and it was obvious that the Indian government response, particularly through the media, was to instead attack Canada, to attack Canadians, to criticize us, to undermine our government and our governance, and quite frankly, the integrity of our democracy. Combined with the fact that as we approached the end of September, it looked like there was going to be media stories detailing some of these allegations that were getting out there. When on the first day that the House returned, we determined that it was in the interest of public safety in Canada to let people know that we knew about these allegations, that we were following up on them. There was an investigation into them that was taken on by police services in Canada to ensure that, partially to ensure that nobody in Canada, in any communities, felt like they needed to take action themselves, that they should trust Canadian institutions to take this threat seriously and follow up on it. And that's exactly what we then did. We launched investigations. The Indian response to these allegations and to our investigations was to double down on attacks against this government, attacks against this government's integrity, attacks against Canada in general, but also to arbitrarily eject dozens of diplomats from Canada, from Canadian diplomats from India on absolutely no cause other than to say, well, we don't like what you said in the House about us, and we're going to punish you for that. This was a situation in which we had clear and certainly now even clearer indications that India had violated Canada's sovereignty, and their response was to double down and attack Canada further rather than take responsibility or say, how can we fix this? Yes, this was a violation of the rule of law, and even take any of the many off-ramps we offered, because we don't want to be in this situation of picking a fight with a significant trading partner with whom we have deep people-to-people ties and a long history and our fellow democracies. But standing up unequivocally for Canadian sovereignty and for the safety of Canadians back then was essential, and absolutely led to the very, very clear pronouncements we made earlier this week that the RCMP, the conclusions and the evidence that the RCMP determined in terms of violence towards Canadians that has been enabled by and directed by, in many cases, the Indian government.
So you've made reference to the allegations that were the announcement of the RCMP earlier this week, and we know that that wasn't solely connected to the Najjar investigation per se. It's a broader thing than that, and it involves allegations of interference by India in promotion of violent extremism, tying agents of the government of India to homicides, violent acts, the use of organized crime, and interference into democratic processes. So it's a much wider thing. And we know that it led to, over the past weekend, the PNGing of 6 Indian diplomats. What can you say? And you mentioned before that the hope was not to blow up the relationship with India after the Najjar murder. Obviously, things have progressed since then. What comment are you able to offer on what the RCMP announced on Monday and where things stand at the moment?
The decision by the RCMP to go forward with that announcement was entirely anchored in public safety and a goal of disrupting the chain of activities that was resulting in drive-by shootings, home invasions, and violent extortion and even murder in and across Canada, particularly in the South Asian community. Largely Sikh, but not exclusively the Sikh community. The goal of disrupting the chain that was diplomats collecting information on Canadians who are opponents or in disagreement with the Modi government, passing along that information to the highest levels within the Indian government, and then having that information directed through criminal organizations like the Lawrence Bishnoi gang to then result in violence against Canadians on the ground. It was the RCMP's determination that that chain or that sequence or that scheme needed to be disrupted, and going public on Monday as they did, and removing those diplomats. The first option was actually being able to question those diplomats and interview those diplomats by having them waive diplomatic immunity. They didn't. That's not surprising that they didn't. Canada wouldn't waive diplomatic immunity in many cases either. But therefore, we had to ask them to leave the country.
Okay. And just to be clear, when you speak of diplomats collecting information in this instance, we're not talking about research and Google searches. We're talking about covert, clandestine.
Covert, clandestine, coercive measures, threatening to withhold family visas, paying sources, a range of things that the RCMP can detail if they feel they are. I mean, one of the important things on this is these are ongoing. There are ongoing court cases and trials. So if the RCMP had its druthers, it wouldn't have revealed any of this. It's just that it hit the threshold before it came out naturally in court through our judicial process, as it would, as much of this will. But the threat to public safety and the need to disrupt preemptively, even before the court cases were fully adjudicated, were made it the RCMP's decision to go public with this.
Okay. Well, as you mentioned, there are ongoing investigations, and in that sense, I think we've probably gone as far as we can go on that topic. So we'll move on. We can take the Najjar document down now. Going back to the chain of events, I think that we can say followed the May 2023 media leaks and the revelation of the PRC interest in Michael Chong. One thing that we know happened was that Minister Mendicino issued a ministerial directive on threats to the security of Canada directed at parliamentarians. And when we spoke about that initiative in camera, you expressed some ambivalence towards the policy. And I'm wondering if you can tell us about that.
I have very little doubt that had there been genuine threats, or there had been deliberate threats to, direct threats, or is the word that CSIS used, direct threats to Michael Chong or his family, that information would have been elevated to at least the Minister of Public Safety, if not directly to my office, on threats to a parliamentarian. But in the messiness of having a criminal leak erroneous information to the media and the attention and worries that ensued, I asked Minister Mendicino to put out a clear directive that said if there's any threats to parliamentarians or their families, that should be automatically elevated, regardless of whether they are credible or single source or reliable or unreliable or not. We need to elevate the attention that is given to parliamentarians' safety. I don't know that it's entirely necessary, if I'm being honest. I have confidence that if there is a threat to a parliamentarian, CSIS and our NSIA and our security apparatus would take it very seriously and make sure there was awareness and follow up on it. But in the moment, and to show Canadians how seriously we were taking this very serious issue, emitting this directive that said, yes, explicitly you have to do it, was a responsible step. I prefer to demonstrate confidence in the decision-making frame of intelligence agencies around how they elevate and how they evaluate information as, okay, this is really credible, we need to see this. This is not so credible, but let's let the local police of jurisdiction or let the RCMP know about this, or like they make determinations around where information should go and what should be done with it every day, all the time, on a whole bunch of different information. And being overly prescriptive is not the ideal way of doing things. But in this case, I think it was a fine thing to do.
Okay, that's fair. The next topic I want to ask you about then is providing classified information to about foreign interference, of course, to party leaders, leaders of political parties or cleared representatives of political parties, as the case may be. The first question I'll ask is fairly general, but when you as a party leader receive information about potential foreign interference happening within your own party, what can you do about it? What are the options available to you in such a scenario?
Oh, there are many, many things I can do. If it comes early enough in the process, I can simply disallow a candidate from running. for a nomination or to be a candidate in my political party. And a party leader, all party leaders have ultimate discretion because Elections Canada requires that the party leader signs off on every single one of the 338 candidates they can run across the country in an election. And withholding that signature from a particular candidate is one of the core responsibilities, or that signature is a core responsibility and powers of a party leader. And it happens at an early enough stage that if someone expresses even publicly that they want to run for the party and don't end up running for the party, there's not necessarily a scandal around them not running. There could be some sour grapes. There could be, oh, I just had to decide to stick with, family was more important or anything. There's all sorts of face-saving ways in which if a leader quietly says, no, there have been concerns raised, you're not going to be able to run for us, but we don't need to talk about it publicly. You can go back to your life. That is a very effective way of having things done that don't require revealing of any classified information, but is based on intelligence that a leader can get. Once someone's an actual MP, a party leader cannot fire an MP. MPs were elected by Canadians. All a party leader can do is, at the largest level, remove them from their party caucus, have them sit as an independent, something that I've done many times for a range of different reasons around sexual misconduct or other things. That's the biggest tool a party leader has. But there's also other tools. If there is an allegation around, to use the National Security and Intelligence Advisor's words herself, around inappropriate behavior or poor judgment or untrustworthiness, as a party leader, I can decide which committees an individual sits on or doesn't sit on, whether I give them a critic role or a parliamentary secretary role or even a minister's role. We have many tools to respond depending on the seriousness of the allegation. If it's that they're overly friendly with a particular consul general, maybe we just say, yeah, you know what, you need to clean that up. And then maybe we can revisit a committee or parliamentary secretary role for you in a couple of years or in a year if the CSIS comes back and says, no, yeah, there's been no contact there or anything like that. There's lots of tools that a party leader can exert to counter real or risks of foreign interference in their party. But it requires the leader to actually be able to receive the classified information from the intelligence agencies to then turn around and take action on that.
Okay. On that topic, I'm going to ask you what happens when you receive intelligence about potential foreign interference having to do not with your own party, but with opposition parties. To do that, I'll ask the court registrar to pull up CAN 047007. So we'll just go through the document to situate us a little bit, and then I'll ask you to pull up a different one. So Prime Minister, this is a memo for you from your NSIA, Nathalie Drouin, in May 2024. You'll see what it says at the beginning of that summary is intelligence details alleged foreign interference activities in Canada directed at opposition parties. Given the serious nature of the allegations, PCO is working with CSIS to develop top secret level briefings for opposition parties on this intelligence, then speaks to various political parties and whether or not they have leaders who are security cleared. And then the last bullet there speaks to PCO sharing a protocol of regarding more regular classified briefings to recognize parties. If we can scroll down again, please. I'll tell you when to stop. Scroll through the background. I think we want to get to page 3. There we go. PCO comment there. So PCO notes that the informing the party leaders could allow them to identify the issues, take any necessary action, and then says an ad hoc approach of sharing intelligence is not ideal, and we should maybe think about doing something more systematic. So if we can take that document down now and put up WIT 164, paragraph 25. This is the publicly disclosable version of the conversation that was had in camera about this. So I'd like it up as a reference point. And I'll just ask you, Prime Minister, to take us through from your recollection what happened here, what the situation was, and what was done about it.
In paragraph 26, you mean?
Yes.
Yeah. I received what I characterize here as explosive, certainly extremely alarming information around foreign interference into a particular political party. And I directed CSIS to try and, or the intelligence agencies to try and ensure that the opposition parties had the tools to respond to these allegations, or had at least the information that would allow them to do this. I have to be really careful about what I say here because this is all very, very sensitive, and even talking about which party these allegations aimed at is something I'm trying to avoid doing.
Fair enough. And I won't ask you many more questions about them because we are treading very thin lines here. The only thing I'll just sum up by saying, so essentially information came to your attention and it was through the system put to the right people in the right places.
I think it is perhaps useful to point out, we don't need to pull it up, but in the, two things. First of all, I'm Prime Minister, so I receive tremendous amount of classified information covering a broad range of individuals across this country, including in different political parties. But as leader of the Liberal Party, it is awkward, to say the least, to use a mild word, for me to be engaging in who should run or what consequences, or who should be a critic, or who should be in what position for an opposition party. So as you pointed out earlier, the answer was to offer classified briefings to all the leaders of the parties so that they could best be positioned to take the necessary actions to protect their MPs, some of whom might be vulnerable, some of whom might be witting or unwitting around foreign interference, and therefore demonstrate to Canadians that the integrity of their parties and the protection of their parties from federal and foreign interference was done, and that was. I can know about it. I don't act on that stuff because I don't believe in the using national security information for partisan purposes, nor should any prime minister. But informing the leader so they can take proper actions is, I think, the right way of doing things. Stepping away from this specific example, because I don't want to weigh into this.
You can take it down.
Example. Because I am Prime Minister and privy to all these informations, I have the names of a number of parliamentarians, former parliamentarians and/or candidates in the Conservative Party of Canada who are engaged or at high risk of, or for whom there is clear intelligence around foreign interference. And I have directed CSIS and others to try and inform the Conservative Party leader to be warned and armed to be able to make decisions that protect the integrity of that party, of its members, from attempts at foreign activities around foreign interference. And the decision by the leader of the Conservative Party to not get those classified briefings means that nobody in his party, not him, and nobody in a position of power knows the names of these individuals and can take appropriate action. It also means nobody's there to stand up for those individuals if the intelligence is shoddy or incomplete or just allegations from a single source. And that is something that as you've seen, we are ready to question intelligence when it comes towards the Liberal Party members, because we need to make sure if you're going to end someone's career, you're doing it in a responsible way. The decision of the leader of the Conservative Party to not receive the necessary clearance to get those names and protect the integrity of his party is bewildering to me and entirely lacks common sense. Particularly when you look at the NSICOP report that clearly lays out, the public NSICOP report that clearly lays out that in both of the most recent Conservative leadership races, there was foreign interference. The fact that there seems to be absolutely no curiosity or openness in trying to figure out what happened or whether someone was compromised or whether a foreign country impacted those leadership races is simply irresponsible. The fact that we see, and I'm getting a little more partisan than I've tried to in this case, but it is so egregious to me that the leader of the official opposition, who is certainly trying very hard to become prime minister, is choosing to play partisan games with foreign interference and accusations around foreign interference, but not taking it the least bit serious as regards to his own responsibilities as party leader, or even to get top officials within his party briefed up as they bring on candidates from across the country, is inexplicable and, quite frankly, concerning. So stepping back from that, our recommendation, and certainly one of the things that is alluded to in some of these reports, and certainly the Commission's work can be, is to indicate that it would probably be pretty important that, as a matter of course, party leaders, certainly of the main political parties, maybe not the Marxist-Leninist candidate that runs against me every election in Papineau, but certainly the main political parties, be given security briefings and clearances that allow them to respond to the very real threats that we have seen of foreign interference in their parties, and that top officials at the party level, as Jeremy Broadhurst was by dint of his day job in my government outside of the campaign period, was able to take that information and discuss with me the consequences that should be meted out, or whether action should be taken or not. It is, I think, a vulnerability to foreign interference that we have as a democracy that some party leaders have decided not to get access to some names that would be very germane for them to at least know and understand the risks around.
Okay, well, we have heard evidence through the Commission's proceedings that foreign interference affects or can affect all political parties. That's certainly true. In terms of providing information to political parties, what about there have been other ideas suggested of how classified information might be provided? For instance, if the leader is a privy councillor, would that entitle them to receiving such information?
There are privy councillors who were sworn in the 70s. As an example, Marco Mendicino was made a privy councillor when he became a minister. But now that he is no longer a minister, in order to appear before this commission and to deal with documents that he himself had generated and worked with as minister, he needed to get security cleared once again. There is a perception around this town that being a privy councillor allows for a higher degree of security clearance or access to documents than not being a privy councillor is. That's simply not true in concrete terms. Ministers have access to secure documents by dint of their roles of ministers and go through a vetting process that clears them for that before they are appointed ministers. But having been a minister years ago does not give you any inherent ability to see classified documents without re-upping or reinstating a security clearance.
Okay. Well, we'll leave that topic for now and go to, I'll ask the registrar to pull up the CSIS IR, which I've lost the doc ID. Can doc 44, please? So, Prime Minister, this is the questions I want to ask you around this are about the commission, and it does relate a little bit to the last point you were making, but the commission essentially asked the government in its proceedings to come up with a list of the significant instances of foreign interference in Canada's democratic institutions and electoral processes over the period of the Commission's review. And this exercise sort of seems brought everyone around the table, considering what was initially a longer list produced by CSIS, and what was eventually obtained was a consensus list of these 6 instances. Many of the incidents that we've heard about over the Commission's proceedings are actually not on this list, but there are 6 that are there. So the first thing I'll ask you is specific, and then I'll actually go to some more general ones. But in terms of being informed about instances as a party leader, on the second bullet there on that list reads, reporting indicates that a foreign government undertook several actions, including interference, to reduce the likelihood of a specific Liberal candidate from being elected federally. It is suspected that the foreign government sought to thwart the candidate's bid, given their support for issues perceived to be contrary to the foreign government's interests. And am I correct in saying that this never came to your attention, this particular instance, before the Commission's proceedings?
Yes, the list of 6 were all, I expected that, as I said, I have access to regular intelligence briefings and updates on these things. It was surprising to me to see number 2 on this list, because I had no idea. And there are lots of details about this that I know that I continue to be astonished that I was not apprised of this, because it was relevant in a whole bunch of different ways and would have been very relevant at the time. But I also understand, without being able to give too much timing or details around this, that processes we have in place now would have meant that there is no doubt I would have been informed about this incident were it happening now. When it happened, we did not have the measures that we have subsequently put in place.
Okay, understood. So this is one you would have liked to see.
Yes, I would have liked to have seen this
Another thing we've heard about the development of this list is, as I said, it brought deputy ministers around the table having conversations about whether some of the instances were or were not foreign interference. And you mentioned earlier in your remarks that there can be different perspectives across government on whether activities are really standard diplomatic activity, for example, or foreign interference. How do you see those debates happening from your vantage point as Prime Minister, first sort of in the existential sense, like, is this a good thing? And when does it come to you and what do you see? Are different perspectives brought to your attention, or how does this play out?
I think it is a very, very good thing that on something as important and sensitive as foreign interference by another state, that there be different perspectives looking at it. As I said, our diplomats in the United States were very alert to, which members of Congress or which governors might be helpful in making a case for a more successful NAFTA renegotiations than others. And that involved a lot of sort of conversations and looking into voting records and, quiet lunches by diplomats in place, and that gathering information on foreign parliamentarians is a core part of diplomacy. And that can be foreign influence, which is something that diplomats are actually hired to do and is a primary job around the country, make sure that the government of the country that you're in representing Canada looks favorably upon Canada. Without crossing into interference. Now, it is possible to use information collected for purposes of influence to then turn around and use it for interference. If a diplomat were to collect the home address of a particular parliamentarian to be able to send them a personal note or a Christmas card that didn't go through the office, that would seem, okay, I'm trying to influence them, make them friendly. That's the work of diplomacy. If that foreign address, that home address was then used to organize a massive intimidation protest in the street in front of that person, paid for by a foreign country, that would be foreign interference, or that would be much more serious. So there is a bit of a continuum on this, and having discussions between Global Affairs Canada diplomats and intelligence agencies and spies and on the push-pull of what is appropriate, what is inappropriate, what is problematic, is more of an art than a science. I mean, it can involve intent. It can involve whether it's a friendly country doing it or an unfriendly country doing it, why they're doing it, what preoccupations there are. There is nuance that is not just across departments, but even within departments. You can have different people within global affairs having a different perspective on that. And all those debates and discussions, I think, are a strength of our system that allow us to come to much more thoughtful answers or measures to take in complex and perhaps delicate situations. So, having those engaged, thoughtful debates in government, and even, quite frankly, to a certain extent, understanding that there are complexities in it for a public engaging with how to protect ourselves from foreign interference is very key. I think of the Baltic states example, when Canada positioned itself as the country lead on the enhanced forward presence in NATO by positioning troops in Latvia. One of the things that we learned about very quickly was the incredibly robust system that citizens in Latvia had to detect and deter and render ineffective Russian disinformation, because Russia is constantly flooding the zone in the Baltic states. And they have a very sophisticated and attentive population in knowing that this piece of information is just Russian propaganda or disinformation, that I think Canada is moving towards. But we are not as far forward as some other countries may be in terms of detecting misinformation and disinformation from hostile state actors.
So when these different perspectives may exist in government, do your officials make you aware of them so that you know that maybe CSIS has a different view on something from GAC?
Yes.
Does this come to your attention?
Yes,
Okay.
absolutely. Either actually in person by watching the director of CSIS and the deputy minister of Foreign Affairs, have a conversation back and forth about a particular thing, or it is obvious in the briefings come to me where it says CSIS leans on this way, but the diplomats say that this might be it, and at the same time, the clerk's decision is this. One of the reasons that I've said I prefer to have active, engaged discussions around intelligence is it allows us to challenge and bring together those different points of view and different perspectives to get a better picture than simply one document that perhaps summarizes different elements, but is written by one person in one department and not another.
Madame la commissaire, je vois que j'ai...
Madam Commissioner, I see that I'm out of time, but I have still 2 topics to tackle with the Prime Minister, if you allow me. Yes, go ahead.
So the next, I do have a couple of more questions to ask you. The next one is on a different topic now, and something that we spoke about at great length in camera. So I think we'll have the Reader's Digest of this conversation today, but the vulnerability of political party processes to foreign interference that has been raised à maintes fois in the Commission's proceedings. And we know that Elections Canada will soon be making some suggestions or recommendations as to things that might be done to ameliorate this situation. Can you give us your viewpoint on the idea of increased oversight or increased regulation of internal political party processes for the purpose of dissuading foreign interference?
First of all, there is already oversight and regulations over political parties in Canada that we all understand is important and necessary. I think of the very strict election financing rules, how a political party can raise money, how it is accountable for every dollar it raises, from whom it receives money, what it can spend the money on, how it needs to account for it. That's a really important principle that applies to all political parties and is sort of foundational for our democracy. So the idea that in our democracy we should regulate political parties is well established, that yes, there are many things in which it's important to uphold the freedom and openness of our democracy, that we regulate political parties. In C70, we actually indicate with greater clarity and legislate around foreign interference in political parties as being illegal. I mean, these are things that, yes, there are certainly things that governments and our democracy should do to ensure the accountability and responsibility of political parties. However, when we get into the issue of determining how a political party picks its candidates, or who gets to be the ultimate decision maker in a political party, or how to structure a political party internally, or how to run its nominations, we get into an area that I think one needs to tread very, very carefully. I mean, one of the things we see first in authoritarian countries like Venezuela, to use an extreme example, is the government regulating what opposition parties can do or say, or how they can organize themselves, or how they fund their fundraise. Is a great way for a party in government to control and render ineffective opposition parties. And that is the last thing that we would ever want in Canada. I think it's extremely important that political parties have a large degree of autonomy in their country, in their operations, independence in how they choose to operate and function as political parties, as opposition parties particularly. But that comes with it a responsibility by those political parties to be able to demonstrate the processes in place that they have to reassure Canadians, but particularly their members, that they are not arbitrary, they are not subject to whims or influence or interference by foreign interests or special interests across the country. That's why, for example, in our party, we have nomination races that have very clear requirements that need to be hit within the party frame. We have an appeals process for anyone who loses a nomination. We have scrutineers and lawyers that every party gets to have on every candidate's team gets to have in the nomination process to ensure that it's a rigorous process. We have created many, many mechanisms like that because the Liberal Party has had nomination races of 6,000, 7,000, 8,000 people contesting for a single nomination. Sorry, 6,000, 7,000 members supporting a handful of candidates contesting for a particular nomination. Are there things that can be done to give political parties more information, better access to it? Well, the first one is making sure people, at least someone in a decision-making position at the top of the party structure, the party organization, the campaign director or someone like that, gets the necessary security clearance so that if CSIS or others see flags, they can carry that to the party or inform the leader about it so the leader can make sure that the processes, whether it's a leadership race or a nomination race, can account and say publicly, this was not interfered with. I think it's on the party itself to demonstrate the measures it has taken to protect itself from interference, rather than a government or even Elections Canada weighing in and saying, you have to do this, this, this to protect from foreign interference. I think it is better for Canadians and media and oppositions to be calling out where a party does not have robust processes in place and is not taking seriously the threats of foreign interference. But overly prescribing or regulating the organization, the behaviors, the structure, the decision-making processes within parties by what is necessarily one party in a position of power in government is something that I think requires a lot of caution. But there are many things that could be recommended for parties to take on as tools to keep them safe that I'm certainly hoping that Elections Canada and the Commission's work will highlight that are important principles for how parties can protect themselves from interference.
Okay. Moving now to a topic that you've raised on a couple of occasions already in your remarks, but not completely directly, is the classified NSICOP report. So as you may know, the Commission was charged with looking into the NSICOP report and has done so. And we've heard some evidence over that process. I'll just highlight a couple of things that came out from that process and that investigation. One of them is some questions raised as to the strength of the conclusions that NSICOP expressed versus the strength of the assessments that CSIS actually made. So NSICOP's conclusions are NSICOP's, not CSIS's. There were also instances in which some discrepancies may have been found between the conclusions again made and the underlying intelligence. We've heard concerns in these proceedings from two of your, well, your former Minister, Mr. Mendocino, current Minister, Minister LeBlanc, about the strength of the public reaction to the NSICOP report. And I'm wondering if you can comment on that, having, of course, read the classified NSICOP report and having knowledge of its contents.
I created the National Security and Intelligence Committee of Parliamentarians for a very specific purpose: to make sure the parliamentarians from all different parties would be able to look into everything that our national security agencies are doing, with at least two clear goals. One is to make sure that our national security agencies are behaving appropriately and not violating Canadians' fundamental rights or overreaching or, or doing the bidding of one particular government versus the well interests of Canadians. Just about every one of our democratic major democracy partners has oversight by parliamentarians of their national security agencies. Canada did not, and the previous Conservative government refused to even begin to entertain the idea that parliamentarians should have the ability to oversee national security agencies. I felt strongly that we needed that, and that's why it was one of the first things that we did or worked on in terms of national security. The second reason NSICOP is important is the first reason is to make sure there's not overreach into, and there's other mechanisms as well, like NCIRA, to make sure there's not overreach into Canadians' fundamental rights. But the second is to make sure that national security agencies are taking seriously all the threats and acting in appropriate ways to counter the threats. But being a body that has only come into being about 8 years ago, and being one, or less than that, 6 years ago, being one that as recently as just a year or two ago in the House of Commons is still contested as to its legitimacy and usefulness, it's still very much in a learning process. It's trying to figure out how to manage a very multi-partisan structure in a highly polarized and partisan environment. When it comes to something like foreign interference, that is such a contentious and worrisome topic that you can imagine that any pronouncement that gets out, whether it's a criminal leaking information to the newspaper or NSICOP, putting out a report or this commission's televised hearings, is generating a lot of interest. Did NSICOP get everything right in its report? As CSIS pointed out, there were some discrepancies. But I don't think that's automatically a bad thing. I think that's part of making sure there are different tools and different perspectives and different organizations working on similar challenges from different things. Yes, there's some of the things that NSICOP put in there that I really would have rather they didn't frame that way, because it worried Canadians and talked about traitors in Parliament, when that is not the assessment that our intelligence agencies put forward. But it's salacious and it sells newspapers and it worries Canadians, so it got put to the fore. I see this more as part of growing pains of building mature, not just institutions around national security within and around government and parliament, but of part of the learning process that citizens get to be part of in figuring out how to talk about real threats and how to evaluate in our democracy, where the lines are and how to best protect our democracy without harming the exact things that make us a free and open democracy. And those are sophisticated conversations that can't just happen within governments or within commissions, but can and should happen as part of active, engaged debate, discourse, and political conversations between elections and during elections. So yeah, there's some things that I feel, certainly with all the perspective I have and all the direct briefings I have from CSIS, that they didn't get quite right. But I much rather have an effective and confident NSICOP committee that goes forth and draws its conclusions and says things that we will all learn to say, okay, yeah, they got this right. They maybe were off a little bit on this, but this helps us advance this understanding. And CSIS was able to come out and correct the record on this. And some of the things that NSICOP talked about, CSIS had actually made a little bit of a mistake. And that was where NSICOP's report was. So that's thoughtful as well. So for me, it's all part of a system that is robust and serious. But because we're in a open, free democracy that stands up for everyone's rights, that is working hard to get it right, but that we don't always need to expect perfection from. And when, as consumers of intelligence materials, individuals and media and opposition parties become more and more experienced at it, more thoughtful about it, Canada will be even better served than we are right now in the important debates we have around foreign interference.
So maybe it's not about getting everything right, but contributing to the building of a national discourse.
Absolutely. Although it'd be nice to get more things right too at the same time.
Fair enough. Madame la Commissaire, ce sont mes questions.
Those are all my questions, Madam Commissioner. Thank you very much.
For Michael Chong. I see Commission Counsel has taken an extra 30 minutes in her examination pursuant to the O'Connor rule.
18.
I thought we were finishing at 11:50.
Clock says 18.
It's okay. Just go on. Tell me.
Okay, well, we'll figure out exactly how much extra, but pursuant to the O'Connor rule that governs in this proceeding, that extra time should be allocated to the parties for their cross to ensure that Commission Counsel's time and the parties' time is equal. So I'm asking that we be given that extra time. We'll have to figure out between ourselves how to allocate it, but I wanted to bring that to your attention straight away.
Okay, let me look into this issue at lunchtime, but we'll let you know through an email.
Thank you, Commissioner.
So we'll take a shorter break today, so lunch today. So make sure to come back at no later than 1:20.
Order, please. Alors, s'il vous plaît. The sitting of the Commission is now in recess until 1:20 p.m. Cette séance de la Commission est maintenant suspendue jusqu'à 13h20.